Welcome everybody to the conference today on the theme of Access of Justice event. The Indian Council of Arbitration is the apex arbitral body in India. It was founded in 1965 as an arbitral body of national importance through the joint efforts of several key arbitral jurisdictions. Ladies and gentlemen, we are extremely privileged that we are joined by some of the best legal minds of the country to enlighten us and ignite our imagination on hot topics in the arbitration landscape. Gracing the event today, we have Honorable Justice Hema Kohli, Judge, Supreme Court of India,
to address this august gathering with participation from senior members of the judiciary, legal fraternity, and dispute resolution practitioners. They all act as the pillars for India to become the most preferred destination for dispute resolution. As India's economy becomes increasingly interconnected with the rest of the world and exhibits dynamic growth, the demand for efficient, fair, and swift resolution of disputes has never been more critical. This was even emphasized by the Government of India at various forums and recently at the Supreme Court's 75th anniversary celebrations. So this highlights the focus on access and ease of justice. Ladies and gentlemen, it is often said that inordinate delay, cost of legal processes, and inaccessibility are impeding the effective delivery of justice. These issues especially aggravate the situation when it comes to economic transactions, where value in hundreds of thousands can be lost in a few minutes. It can also impede investments and ultimately the growth of the economy. So to ensure timely, cost-effective and accessible solutions, it is most pertinent to have credible alternate means of dispute resolution like arbitration and mediation.
COVID-19 pandemic has brought about an unprecedented global crisis that has affected all aspects of life, including our judicial process. In India, the pandemic has made the courts and the lawyers adapt and evolve to face the challenges of the current times. Just on a lighter note, and we were just speaking about it a few minutes before we assembled here, when courts were being conducted virtually, one of the most hottest destinations was Goa, where most of the lawyers that we were aware of decided to park themselves and connect virtually to almost all courts that were functioning virtually across the Supreme Court and the state high courts. So that shows the popularity of Goa as a preferred destination. I can also share my experiences on how the COVID times worked for us. When I was presiding as a division bench in the Delhi High Court just before the lockdown was declared in March 2020, my bench partner, Justice Prasad, had flown down to Chennai from Delhi to be with his family, and he couldn't return back because all the flights were cancelled. Separated by a distance of over 1,700 kilometers, we seamlessly conducted court online for almost 1 month. Again, when I went as Chief Justice to Hyderabad, one of my colleagues at that time had travelled to meet his family at Chicago. That was around June of 21 or May, I think. And he could not return to India because of the lockdown and cancellation of flights. So our IT team in Telangana linked him up with his bench partner in Hyderabad, and they could successfully conduct court hearings while living in 2 different time zones for almost a month. A paradigm shift towards online dispute resolution, as we call it ODR mechanisms, has taken place in the field of arbitration and mediation as well. Digitalization has improved the efficiency of the arbitration process. It has helped prevent loss or damage to important records. The availability of digital records has also made enforcement of awards more efficient, reduced the burden of evidentiary challenges to court, and Indian courts have readjusted to modern times by offering an option of virtual hearings to lawyers and litigants.
Effectively resolving the disputes. Resort to ADR is now inevitable. But this should not be done only to reduce the arrears in the courts. Reduction of the pressure on the docket of the courts is certainly one of the objectives. But to quote our present Chief Justice of India, Justice Chandrachud, he explains that mediation as a procedural intervention in the legal system fulfills other instrumental and intrinsic functions of equal, if not greater importance. In its instrumental functions, mediation is a means to fulfill the stated objectives such as quickness, reduced costs, informality of procedure, and greater participation of the parties in the process. But the intrinsic function of mediation emphasizes that mediation is an end in itself. The peace that mediation is able to achieve is much more enduring and satisfying than a verdict through usual litigative process or even an award in an arbitral process. It is right that litigation involves delays, expenses, rigidity of procedures, and even minimal participation of the parties themselves. J.S. Orbach, in his classic piece, Welcome to Litigation, says that it is virtually impossible to survive litigation and yet remain solvent. But it is occasionally possible to endorse it and remain sane. As a modern ordeal by torture, litigation excels. It is extraordinarily expensive, agonizingly slow, and exquisitely designed to avoid any resemblance to fairness or to justice. Yet, he says, in strange and diverse ways, it does settle disputes, but to everyone's dissatisfaction. All this at least has a chance to be minimized, if not eliminated, by resorting to ADR instead of litigation in the first instance. Recently, I read a piece by Joseph Markowitz, an eminent mediator, analyzing President Lincoln's 3 quotes on with you before I conclude. In the first, President Lincoln says, discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the real loser. Increase expenses and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough. Lawyers owe a solemn duty to explain to their clients the full range of costs, timelines, and even the frustrations before taking the first step to litigation. Greg Relia has made a comparison between lawyers and gladiators. He says that the present-day lawyers battle with arms of logic instead of lances, with statutes instead of swords, with rhetoric instead of physical force. But now he says there is a dire need for lawyers to transform themselves from gladiators to mediators. Judges too need to develop a culture and an environment that encourages the resolution of disputes through ADR. In the second, President Lincoln says, quarrel not at all. No person resolved to make the most of himself can spare time for personal contention.